Okay, and we're live. Well done, council officers. It's been a really, really intense 2 days. And I think we made a lot of progress with a lot of submissions. So as normal, we'll hand it over to you to give us a response to what you've heard. And in particular, there's a couple of things that we want to obviously do forward on. One thing, people, and
shall I go first?
James, who's going to manage this?
I think we'll essentially look to, given the remote nature and the difficulty it is to engage a little bit, what I might suggest is, yes, the officers might wish to come up and sit in the front and engage directly with you. I might suggest Mr. Baxter first. Mr. Baxter also has a young family, so if we resolve any issues outstanding with Mr. Baxter, we can send him off on his merry way to see his family.
That sounds like an excellent.
You want me to sit up there, or?
I'm quite happy for you to stay seated where you are.
Yeah.
But I don't want to cut across your boss.
Yeah, no, that's okay. Yeah, from my perspective, there's not really anything to respond to in relation to Motukiki Island, except for perhaps structural changes that with consistency, whatever Mr. Wyatt sides on. Yeah, so that's kind of where I'm at. Yeah.
Yeah. Okay. So where Mr. White goes on this, you probably agree.
Yeah, that's fine. Yeah, that's about it for me.
Thank you, Mr. Baxter. You may leave. You're allowed to go home. Don't wait for the bell.
See you later. Yeah.
Yeah, perhaps we might go to Miss Morgan next.
So I think that in terms of Waitangi, we have the issues that the panel indicated you were going to give some thought to. Are we in a position at the moment for that?
Yeah, what I understand is that you've spent a lot of time with the consultants addressing these matters. That's correct?
Yeah, that's correct. So there's been a lot of backwards and forwards. We've spent a lot of time working with them in terms of their chapter. In fact, we had to invite them to give us a chapter in a section 32 a report before we kicked it off the ground. And there's been a lot of work both by myself, James and Ms. Pearson to get the provisions where they were. I think it would be fair to say that there is still some work to do about where we are at the moment. And I'd like the opportunity to be able to work further on the provisions when we don't agree. I think there is some work to do there.
Well, look, I had a really chat with them after we closed yesterday, just to get a sense of what they're trying to get out of the process as well. And I got the impression, quite a strong impression, that they were looking for some direction from us as well. So I think a focused minute based on expert conferencing, clearly focused on those matters outstanding, is probably a good idea from us.
I'd really appreciate that because I think that would give the planners and
what we'd like from you is maybe a few notes to AK as to what you think the expert conferencing could be focused on. I've got a fair idea, but I'd like you.
Would you like me to give you an indication now?
Well, you can give us an indication now, but if you could give it also in writing to AK, I think that'll help us focus that minute.
So, I mean, I don't at the moment really where we're sitting. This might expand. So I'm just really at the moment. We'd be looking at NFL 1. We're still, I think, a long way apart about that because we heard the 3-tier system. We hadn't heard about that until yesterday. This was, she had a 30, a 30 to 50 and a 50. That was new yesterday. So I'd like to talk further about that. We're a part about temporary activities and we're a part about signs. Part of the temporary activities, we need to look at the Waitangi commercial activities definition. So those are things that I would be pushing in the conferencing. I think it would be fair that the planners in the room would at least be Waitangi Limited, would definitely be Mr. Bracey and council planners. Also probably what we want is an steer from you as to whether you'd want
3 parties, council,
three parties,
heritage,
yes,
and planners.
yes, only planners. And it would make sense to have those people in the room. But we're open for a direction from you if you think of any other planners.
No, I having been involved in the conferencing a lot, I tend to want to keep it within experts and keep it narrow. The narrower the better, I think. And I think we are talking about purely planning issues
It's really nailing that temporary activity.
in the NFL.
Yeah, that's going to be tough.
In the size. How far we are on size? So we getting picked?
You can't be too far apart on that.
But I'd say
Look, I think,
we get a lot more evidence on signage, so we're really interested in the response to that.
yes. The issue, we also want a direction as to whether you want us to report. I think we need to report back to you and how you want that done. So those are directions that I'll be putting to AK and asking for some clear direction from you. If we don't reach agreement, I'd be seeking 4 weeks for our right of reply.
I think that too. I think we're going to have one round of conferencing. And if there is still areas of disagreement, I think we would probably move to a right of reply and we'll take it from there, I think.
Because, and I think, my thinking is that if we reach agreement, we would provide that with our feedback, or with our memo in respect of the conferencing. If we don't, then I have to address everything in the right of reply.
And what
2 weeks for the conferencing, is that agreeable to you?
I think that sounds reasonable. I think the indication was that they are available. That Waitangi is available. Mr. Bracey certainly made us feel as if he was available.
So on that, I'd rather leave any of my comments to the conferencing rather than, unless of course that's not agreeable to you. I just feel that the conferencing is the place where we thresh out some of these issues. However, mainly because I think that at the end of the day, I think we will reach agreement in conferencing. I really do.
So, I had a quick look back at some of the materials last night, and I was, while we were hearing the evidence, I was struggling about this whole issue of public access and tracks and why this trail kept on coming up. Is that because that trail was the Te Araroa trail that has its own status and must remain open under what the Reserves Act? Whatever it is, that it must remain open. And the concern is that if there is unlimited temporary activities, it may inhibit the operation of that trail to remain open. Is that the concern?
No, sir. Look, the Te Araroa Trail is the national walk of New Zealand. So it essentially goes from the very top to the very bottom of New Zealand. For all intents and purposes, it is a public place. It's in relation to their viewpoint on signs that their own little community and doesn't have a wider effect if there's a proliferation of sign on that property, notwithstanding that they are the caretakers of New Zealand's national place associated with that, and their requests for a diversion away from the rest of the signs framework. So that's the concern, is that, you know, what if they're asking for a no public place, or now they've changed that, gone to potentially viewable from the estate, would that be included? We wanted to be clear about when it would and wouldn't apply. So it's just certainty around how their provision would work.
I think
So it's purely about signage and who views it.
there is also an argument.
As a viewpoint.
There's also an argument about access to the public, and I want to reserve my position about that in a right of reply. I think the issue is that the council is. We heard a lot about trust us, and the council is person that is the other parties. We are the other parties, and the cultural advisor raised that, and in 10 years' time, there might be different people at the table, and at the end of the day, it's up to the council to put in a framework that ensures that the trust is there, still there. And that's one of my issues in respect of the temporary activities, is that it must be a framework that allows that access when it should be. And so, and I want.
And I think you're concerned about temporary activities. It may frustrate that access.
It's what it is.
I mean, I'll just play devil's advocate for a moment and just say, well, Waitangi, they will be under an obligation to maintain access themselves. And if they were to be managing whatever level of temporary access, they would be under that obligation no matter what number or duration of temporary activities you would allow. So it would be for them to keep that open.
But that's the issue. If you don't have a framework around that, given what the definition in this plan is, which is public access, and that's the point that I'm wondering has been missing, and that's why this suggestion for everyone to conference is quite good, because I'm wondering if that little part of the definition, in the desire to get a chapter. Yes, the plan. Yeah, the plan definition of temporary activities.
There's a possible way forward. I'm just discussing options here. There's a possible, I mean, because you're a special purpose zone, is there an opportunity to define temporary access differently? If there is temporary activity differently
in relation
for
to
this zone?
Yes. Oh, yeah, and it could be. I mean, I'm not
You might
making
call it temporary something else.
well, and I'm not making a judgment on that. I'm having a.
You call them temporary events. So,
And that is a definition that other plans throughout New Zealand have used. And again, those are things that could be raised in conferencing, which is the beauty of it, which is why it's been suggested. However, at the moment, they are subject to the current definition, which we have temporary activities, which has this public access, which unfortunately has almost got lost.
but you acknowledge that that's a possible option to resolve.
Yes, yes, absolutely.
As you are a special zone, you can define those activities for that zone. But, okay, so I suppose what you're saying is you want to see if you can't resolve it with the definition that
Absolutely.
it might first, and then look at other options. And
Absolutely, yes.
conferencing might achieve that. Okay, cool. Anyone else? That does my thing, doesn't it?
Yes, that's me.
Signage, temporary activities in the NFL.
Thank you, Mr. Chair, that we must move on to Mr. Wyeth and his cache of special purpose zones and precincts.
So, landing first.
Oh, yeah, I was going to start with these ones. Well, some of the overarching, maybe some further consideration around strategic direction of considerations that need to be amended as a result of the improvements.
I'm right, I don't have a firm view on it. I just think that the two, obviously that was raised. And I've always kept that in the back of my mind. We've had a look at that evidence and came up with a sort of like a preliminary working finding on it, knowing that we might need to revisit it, and here we are. I think as I recall, was it you who was on that one? The strategic direction?
I believe that was Melissa.
Oh, there's worse up there than it was too. And I think the right of reply said that the approach to restoration and replanting by hand conservation was an important outcome that didn't reach the level of strategic outcome.
I actually think that might have been Sarah Trinder than myself.
Well, anyway, we can look back at it.
So the question is really, maybe you might want to have another look at it and think, well, now that we've got, I suppose there are two arguments. Now that you've got 3 or 4 or 5 precincts that are specifically recognising that approach to rural areas, whether that possibly elevates it into a strategic outcome, or the corollary of it as well, the zones are there, you don't need it. This is the whole where I thought he would go. Because this sort of demonstrates my point. You've provided it qualified properly. Perhaps it does deserve its own strategic position. We're reasonably agnostic as to whether you do or not. You happen to have these 2 commissioners review at the time, so do you have anything?
No, I think you've covered it. I do remember from Mr. Hall.
Next issue was the overall drafting approach. Includes whether it's in the overview, advice notes, part 1 in terms of how to change works. We'll put some due consideration to that.
Yeah.
Potentially also get some advice notes to make sure what we're proposing is robust, and that would apply across the precincts. And then it goes on to the landing. So you see there's kind of 6 discrete issues that they're going to come back to on. A lot of that was around the clarification of the plan, the building locations where they haven't been identified, and how that relates to the overlays, and particularly the building lights relating to the overlays. So one's there.
Yeah, they had a bit of work to do, didn't they? They came along, everything was kosher, but then
The plan has been a work in progress, hasn't it?
It has. I keep pushing.
we need some more dots.
Yeah. So I think there was the dots on the houses that haven't got dots. Showing where all the dwellings that have been formed are. Existing dwellings. Showing existing revegetation and proposed revegetation.
Justifying 9 metre height.
9 metre height.
You're looking at that in relation to those.
Yeah, and that's got a bit of a crossover in Massacre too. So that's sort of become a multi-precinct issue. I have to say, and there's the colours to landing. Yeah, have a think about whether they satisfy the being distinct from the colours that apply special.
As I said, everywhere that a special purpose zone or precinct has been proposed in those overlays, they've adopted those colour materials.
Yeah.
That's without question.
That's the answer.
Look,
That's the answer.
see, I think the guidance from us would be, the circumstances have to be fairly unusual, if not unique.
I wouldn't spend too much time on that. I think it's pretty straightforward.
Yeah.
Yeah, I think it's good for me. Yeah, the 9 metre height thing. I thought it was interesting discussion with regards to the potential for a 3-story dwelling. I think we have to assume that if someone could do it, they probably would try. Notwithstanding Mr. Williams' genuine commitment to not allowing that sort of development, who knows? He could disappear.
You can see some of the scale properly when you're there tomorrow.
Yeah.
Assuming 3-story.
I zoomed in on a couple of dwellings. So, and obviously the lots aren't cheap, so people are going to do something substantial. And possibly all from overseas.
Sorry, just before we move on from that, Ms. Zeta has just emailed me asking what the time frame is for them to work with you on it.
Oh, we're literally talking about it now.
Yeah,
Yeah, we see like Tuesday next week.
she's mentioned next Friday. What was that
I think we indicated that we couldn't look at it until after Monday, but that time frame will probably move to Wednesday. So perhaps on review. So Mr. Wyeth, how does Thursday sound?
Yeah, or in the next.
Yeah, she said Friday. She said Friday, and I think, can you
This
listen
Friday,
Friday?
next
Yeah,
Friday.
next
Next
Friday.
Friday.
For them to be in touch with you.
Yeah, well, to provide all those outstanding.
Okay, next Friday for them to Friday.
Yeah, and clarify any points along the way, they can just get in touch.
But she can get back to you from Tuesday.
Yeah, well, they can get in touch anytime, but it's just the deadline for providing information.
Thanks. Thank you, sorry.
So thank you. That was well timed, actually.
Well, Amanda, I don't need to make that standing. I'll just respond to the whole in terms of those outstanding issues and where I stand in relation to them. But as I said, there's two kind of outstanding disagree with, so relatively minor. Now to the more tricky ones. Maybe I'll start with greening first.
Sorry, there was the 2-story issue as well.
Yeah, height and 2-story.
I think 2-story.
They seem to concede that
Yes.
on the spot.
Yeah, Williams. Too.
He seemed to concede 2-story, but let's confirm that.
Yes, in terms of greening, as a sort of indicator, I don't think it warrants a special purpose, and I can probably steer from you, don't you agree with that? And we're open to exploring more targeted solutions. That, in my view, is the kind of the land use and the activities they're looking to enable. But probably a more tricky component is the actual vegetation.
Wind you back a little bit. Special purpose zones definitely out. Preset. Better, but not really support.
I just wonder if it's a little bit overcooked. Potentially, as I said, I'm supportive of the vision, and I do think having a precinct set provisions, objectives and policies helps to articulate what they're trying to achieve in that area. More so than a special like a control layer would. So probably need to work through that. I definitely think it would be like concise and targeted in terms of those provisions.
Could you just tell us about how a control layout would actually work? Would it just be like in this land and you would define it by
Spatially, just be like a spatially defined area that click on that, in a specific rule and rule reduction chapter would apply. Provide for
so in this area, which would be defined on the plan.
Yeah.
And it would have a name.
Yeah, it would have a name, have to have a name.
To per control layer or something. Yeah. To per control layer with a working title.
Yeah.
And then the following additional.
Potentially, yeah.
So that's sort of like a precinct. Sort of a Reader's Digest version of precinct. Precinct.
I mean, it's just a very specific modification of rather than them guessing we were
Precinct light.
Visitor accommodation or education facilities.
Yeah, because what you're saying is it's visitor accommodation, it's ecotourism, and it's the vegetation clearance of areas that they may plant. Talk about that, you see.
Yeah.
And areas that they may plant, that they are so limited, it doesn't justify a whole precinct chapter, but it would like precinct light.
Yeah, that's kind of my view of where. I've got a feeling they'd like something. Well, they obviously do want something that's more comprehensive, but any perspective that's actually needed, given that these activities are more than likely not going to happen for quite a wee while. So that we might be overcooking the solution. Something that's not yet a problem. I think that my view is that we could set out the options with some pros and cons. Third option and give you to make that decision.
A question of vegetation and clearance. So,
Naturally occurring versus plant.
yeah, I mean, I can understand where he's coming from. He wants to plant first and develop later. It's a bit clunky, but I suspect he's probably going to be the only one in the district that is wanting to go about things that way. I think there was a real consensus building that it shouldn't be areas that are natural. It should only apply to areas that he plants, has planted within a period of time. Just to plant. Have a think about that.
Yeah, so that's definitely got to give some thought to that. Because like there's certainly risk in applying that more broadly. So you have to say in this specific area, because we recognise that doing all this work, we're going to give you a specific type of rule that relates to clearance of vegetation that you're planted, provided that there's certainty on that. So we still need to work through how this will work as a rule.
I sort of feel that he really wants to have these things in the bush.
Yeah.
Surrounded by the vegetation. Yeah. And I can understand that, but I think we all agree that that shouldn't be allowed to go into like really established natural areas where you're potentially felling significant trees.
And as I said,
Unless you think that's okay. Sorry, I know you're not involved. I'm not involved. I'm looking at you.
as I said, it's the higher order documents that we need to get.
Yeah, that's things high.
A lot of it's in the coastal environment. It's strong words.
Yeah.
So I actually think it should probably be a consenting regime for that clearance, not just.
Yeah, and so maybe controlled and discretionary.
You've got a certainty around it.
And that you're not.
Council status side. Yeah. I mean, you're giving up a bit for them to have a more enabling pathway. It just needs to have appropriate oversight.
Okay.
I think that's much more workable, in my view, than the biodiversity value index as a PA standard. I just don't think that's really going to work.
Well, I mean,
requirements for.
Is that a thing beyond this site, or?
I think it's a concept largely posed by Mr. Craig.
Yeah, I don't think it's its own thing.
It's already good, but as a
It's not a
tool.
It's not a peer reviewed standard that applies, internationally or anything, or even nationally. It seems to me that it's an index that he's developed himself.
Yeah.
It may become. It might do, but that's why a very different pathway.
And as I sort of said in my 42A, there's a whole lot of work going on at central government level around biodiversity credits. The solution here is quite limited at the moment. Some of that stuff. But yeah, as I said, I think a more targeted solution will get some advice on. Anything else you want to add on that, James?
Not at all. Like I support Jerome's thinking on this. Yep. You're checking around the higher order policy documents, and I think we all want to find a way to principally support the outcomes that are being sought in just a robust way that doesn't compromise other frameworks that we've got running in the PDP. So yeah, absolutely.
Okay.
Next one is Opua. So we had a discussion, obviously we've got Matt and Jane online here around, I guess, where our preference might be and where your preference might be. And I guess there's two options, there's more than two options, but one would be to sort of give final holding limited, so that we can come back to us on they think the preferences and why we can sort of work with that and give our preferred option.
Well, I think they pretty much pretty clear, didn't they? They wanted a whole lot of things to be permitted that would match what the mixed use zone allows, or they would go back to the NZ.
Yeah, they're not necessarily going
We'll
back.
go back, we'll go to
Yeah.
NZ on its own. And I want to hear what the sort of urban design outcome implications are with either of those sorts of possibilities.
Sounds like a segue, Jane.
It does, doesn't it?
Hi. My preference is to work with the provisions they've put on the table. They've got a very clear vision, and I've acknowledged that I'm supportive of the vision to create this marina destination mixed use area. My concern initially was around how we can send a comprehensive outcome here and avoid piecemeal development. I think the process has been a little bit clunky from their perspective in terms of the information that we've had, that we've received over the course of the process. So I think we've made some really good progress with trying to create a framework here that aligns with the vision. But it wasn't clear how we would achieve this comprehensive outcome, and how the development would get staged. And so that's been, I guess, the premise of additional kind of information requests from them. The other aspect is, I guess, the extent of built development, and I think this comes to your question around, well, mixed use zone and what's enabled through that versus what they're looking to achieve through this this new suite of provisions. And to be fair, that information, as far as I'm aware, hasn't been tabled, so we've struggled to get the information that we really needed in order to assess what the effects of the differences between you know, a mixed use versus the precinct approach. So we would have to do that analysis in order to fully understand that. That information hasn't really been forthcoming. So I guess from my perspective, the preference would be to work with the framework they've put on the table and look to see if we can fine tune it around just dotting our T's and, dealing with some of the concerns that we have around the extent built development, the ability to achieve an appropriate public realm outcome, and some of the connectivity issues, and the built form, the scale of development. So they're seeking a 16-metre height limit. I have expressed concerns in relation to that, and Ms. Epsilon has also expressed concern in relation to that. So I guess we could look to have a conversation around height. We can have a conversation around the extent built development, how their proposal and the provisions that put on the table compare with a mixed use zone. I'm not aware that we've got that information in order to understand what the differences are.
Yeah, I mean, what I got from the evidence today was, in order to bring the two parties together, they wanted to see a lot more permitted activities. And I think that might run headlong into your concerns regarding piecemeal development. So I sort of see that, I mean, that might appear a bit black and white, but that was how I was reading it. And I don't know how we resolve that.
And I think from what you're saying, Jane, too, it seems to be putting a lot back on the council and council's officers, council's consultants to bring something forward in terms of the array of information they provided.
Yeah, look, we have flagged these issues right from the initial review we did of the package, and I guess we haven't been given the certainty that piecemeal development will be managed in a certain way. It's unclear in my mind how the consenting pathway would work when it comes to the public realm and the integration, I guess, aspects of the overall precinct. Now, there may be another way that we can tackle that through some kind of comprehensive development plan, but that's something I'm obviously interested in, because I guess there's some aspects of their master plan which they've used as a base for providing some schedules of areas and heights, etc., that needs assessment. It has a number of shortcomings, and we either tackle that through a process where a comprehensive development plan enables a full assessment of the overall proposal, or we've got to chip away at improving the assessment matters, the built form standards, in order to relieve our concerns from an urban design perspective.
Thank you. Yeah, I'm just wondering what our next step is then, Mr.
I'm not entirely clear what the best way forward is. I felt like I just going back, like we highlighted these issues earlier with the proposal and their submission, gave them like a couple months to respond. We had a proposal that they submitted 7th of July, which we thought made a lot of progress. We made some further recommendations to that further fully play, but thought we're heading in the right direction. I think we could either, I guess we need to assess the mixed-use zone by itself, because it's never been proposed as that, or assessed by us, or that wasn't our understanding that was the option. That's just come in other evidence, so we need to look at that.
Well, I specifically clarified that, Mr. Sampson. He seemed to make it quite clear that is an amended relief.
I guess that's our two options, I guess. So, and I think there's going to be, issues to work through a viable approach. One might have some piecemeal, one might have more risk than the other.
But I think what happens is Final Holdings wants council to concede that a lot of things should be permitted. Now, whether you put a plan in place that outlines exactly what those permitted things is, that's an option. But is council happy with having a development plan option? That would be the only one planned. Others could emerge, but that would be the only one. Does that create an issue?
Like a comprehensive development rule type of thing. We need to give us some more thought.
You still have to have an activity status that allowed you some discretion.
Yes, it'd have to be a development over a certain threshold.
So you're not going to overcome the piecemeal.
Yeah, and then they potentially won't be happy with where we set that threshold for that comprehensive development plan.
I mean, this whole question now, it seems to me that if you enable the level of permitted activities that Mr. Sanson was referring, then you would have to concede that some sort of piecemeal development would occur, because you would need no consent to do it. So it seems to me that you've got a little bit of a policy disjunct here. The outcome that you think the vision requires is a series of resource consents and a comprehensive development approach. And they're saying, well, we've got so many other things going on, we're probably going to have to do things in a piecemeal way, but we do it with trust us.
Yeah, Mr. Chair, I think that is the risk that we need to understand is that risk of piecemeal versus actually a more targeted planning framework which aligns with their vision. And I mean, there's lots of very positive words within their objectives and policies assessment and their development guidelines, lots of really positive comments and criteria there that aligns with what the applicant was talking to in terms of what they're wanting to achieve. So I think that the crux of it is, do we risk a piecemeal outcome, but we've got a framework that is looking to strive to achieve good design, and potentially a question mark around, is it an overdevelopment of the site or not? And I guess that's how I see it in terms of the risks from a design perspective.
Yeah, I mean, I suppose one of the other things is if we default back to a mixed use zone on its own, isn't that going to be piecemeal development?
Potentially.
Yes.
The whole proposal was this kind of integrated in a world-class environment. It's got to transform. It was all of that vision. I guess we were trying to go with visions, like defaulting back to reduce zone doesn't.
But they left the integrated part at home.
Yeah. They want to be world class without being integrated.
I think, Mr. Chair, look, I think we're quite clear on the issues. I'm thinking, yeah, we did have quite a helpful discussion in between the short break that we had. I think what I'm hearing is that we're not clear on whether it's going to be fit for purpose, a mixed use type of approach, and we perhaps maybe want a little bit more of an integrated approach. We had some thoughts. We have been working. I think that there may be limited benefit in further engagement, but I think there might be some. And I know, and I wouldn't normally support officers picking up the baton on this one, but there may be some creative solutions where we could look for win-wins that we might want to put to them. I think there may be some options for us, but I think it would be a very narrow process. I think it would be for us. This is what we've come up with. We'd probably engage with Whānau Authority to say, look, this is what we're going to propose to the panel, and these are the reasons why, and that's probably as part of our right of reply, and that might just about be it in terms of last chance saloon for I guess position on it.
Yeah, so I mean, I haven't heard what the other panel members had to say, but as far as I'm concerned, you know, if we're not satisfied that the submitter has addressed the issues, then you know perhaps the notified zoning is where we land, and then another process sorted out.
I think what we're hearing, I think, Mr. Chair, is there's some go green shoots, to borrow a government term, in what they've provided us, and I feel like you know there's a lot of overlap. They might not perhaps ideally like what we come up with, but I think there's some resources in there. Just listening to Ms. Rennie, that we actually could use to come up with a solution, and I think missing out on that opportunity might be unfortunate.
Well, I think it would be very unfortunate. So I suppose what I'm signaling is the default position of the panel is probably going to be notified zoning. If it doesn't get resolved, and that's, you know, I don't know whether Whānau Holdings would want that outcome.
I think Sanson conceded that at one stage in one of the statements of going back to the new zoning.
Well, it's never been that sort of thing. It's only been
Accepting that, but not going on to anything further.
Yeah, yeah, but I think what we're discussing is that if we choose to zone it mixed use zoning, we are essentially enabling piecemeal development, which is the expert advice of council officers. So if we don't, then you're stuck with the default zoning, which is what was notified.
And is that not piecemeal?
Well, it provides for limited. It's limited. It limits the piecemeal because we don't residential. But I sort of feel like, you know, we can't design it.
That's not a line, isn't it?
Yeah. So.
And at the end of the day, we're engaged to sort of make decisions on what's put in front of us, not to be, you know, asking our council officers to take what they're given and see if they can ramp it up to acceptability.
We would, again, we don't want to waste. We don't want to expend time that isn't going to be productive. But I think, you know, last chance saloon, it could be one. We would definitely, I think, encourage some further engagement. And we're happy to write a direction to that effect that sort of says, you know, here are the options as we see it, and it might result in the notified zoning. We really encourage the party to try and work something out, and then just see where that goes. Any comments on that?
I mean, you could direct us to engage on the options being notified zoning. Myself,
Yeah.
we need to on that kind of third option, which would be what's in what is way or some recommended amendments.
Yeah, because at the end of the day, we've got to make a recommendation for the council of the land to be zoned. And if parties have explored all these other options and got a line, then we can then agree on. Maybe we have to look at what notified is. We have to assume the council doesn't oppose its notified zoning.
It's light industrial.
He said what? Okay, well, I think that's good. That's it.
Probably what I'd like to highlight is that we're zoning, a lot of zoning rolled over to some degree. So may not have been the attention given as to the implication.
Yeah. I think they really just wanted the same rate regime to apply.
Yeah, the regime is very different between what was industrial and industrial now. So you have to look very carefully at that. That might be an unintended consequence.
Sorry, just, overall running.
Oh, yeah, we often have a few comments about, we received some, very, very well intentioned and well articulated lay evidence. I think what we would like to be advised on is what is the existing environment in terms of what's being consented, partially given effect to. There is a consent there. I think that'd be helpful for us to confirm what that existing environment is.
Mr. Chairman, it may be of some assistance to you, but I took the opportunity to go to the actual consent and have a look at the volumes.
Yes.
What was actually proposed, and it's between 1.5 and 3.5 metres deep over, over how big an area it takes to take however many thousand cubic metres it was. But that's what the consent.
I would like that too. That's a lot of film.
It is a lot of film.
45,000.
Between 1.5 and 3.5 deep, they have consent for.
Yeah, so we've got an existing environment that we obviously have to have, not even have regard to, we have to acknowledge. And that might be the situation.
And if you're going to look at retaining it in some form or the other, I mean, these people should have seized on that at a much earlier time from all accounts, before a consent got granted and influence what might happen.
I mean, other provinces are impression themselves, if they don't get affected that consent, I think all bets are off.
Yeah, back under the years, it's going to be a different outcome.
Oh, completely. I mean, crikey, it would possibly, look at where the bar is, what's a wetland or not. What's a stream?
Yeah.
And the use of artificial structures to transform land. There's the NES and the MPS all have stuff on that. So yeah. So, but look, the existing environment is the existing environment. I need to be bound by that.
That's been my starting point. So yeah.
Oh, just so you know, we are going to be visiting 3, possibly 4 sites. We're going to go to Waitangi first, and then we're going to go to Ataka Station, and we'll have lunch with them, and then we'll visit the landing. And Opua will be looked at some point. I thought we might try and do it today, but that's no.
Drive past.
It might be drive by. Yeah, we might look at doing it early tomorrow morning before we go to Waitangi. I don't think it needs to be long. For those of the sites that we're looking at, we're not going to go to Tupou. I'm not even sure we could access anything of there that would assist us anyway.
It's necessary.
You're not wanting us to look at anything else? I'd love to go to Motukiki Island, but I think the effort and the fact that there would be nothing to determine, it's probably stop that one.
If you get the opportunity, and they probably will give you the opportunity, they certainly did with us at the landing, is make sure that you don't only look at the developed bit, but look at the bit further west, south and west, which is still under revegetation process and still being farmed.
Right, okay.
So that you can see that part of the landing is the bit that's most like Matakara next door.
Right.
All-wheel drive. Horses.
Okay, good. Well, look, folks, I think I believe we'll go home. It's 5 o'clock. Thank you very much. It's been a really interesting hearing. See you all in 3 weeks' time for 15C. See?
Yep.
All at the environment court.
I'll just close us with a karakia. Taruki whakataha, whakaere te wānanga, kia wātia, aira, kua wātia, huie tākie.
Tākie.
Thank you, and I will end the recording.